Welcome back. Thank you for coming back timely. I'm delighted to be chairing this session. I'm going to I'm not going to introduce all the speakers at once because we have 5 speakers, so you'll forget who they are. So I'll introduce them in turn. I'm going to give each speaker 15 minutes. My hope is then that we can save time for questions and still finish on time, make up some time so we can finish at 4, because I don't want to rob the next panel of any of their speaking time. And I have a couple of thoughts just to think about. We've talked a lot about, in the first 2 sessions, about racial harmony. I think that's a good thing to think about, but I think we should also think about racial justice in the next 2 panels. And we've also talked about the EOC having a role as a regulator, which it certainly does, but I do want to remind everyone that the EOC also has an advocacy role. When I was there when the EOC was created, and I remember the women's groups and the disability groups, they wanted an EOC because they felt they needed an advocate for equality, not just a regulator. So I think we have to bear in mind the relationship between the law and the EOC is to achieve racial justice, and that takes a certain amount of advocacy. All right, I'm delighted to introduce our first speaker. Andrew Burns is well known to many of us. He is now a professor of law at the University of New South Wales, where he's also the Associate Dean for Research. Previously, Andrew was a professor of law at Australian National University from 2001 to 2005, and before that he was a member of the Faculty of Law here at the University of Hong Kong, where he taught for more than 10 years, and he was the first director of the Center for Comparative and Public Law. And many of you may also know that Andrew was responsible for establishing our LLM in human rights. He's dearly missed, I know, at the University of Hong Kong. And
thank you very much, Carol, for those kind words, although I should say, of course, that there were many others involved in both the establishment of CCPL, which I see has gone on from strength to strength under Carol's leadership, and also Hua Ling's leadership in subsequent years, and also on the Masters of Human Rights, particularly Johannes and Yash and Carol, all of whom were involved in different ways. Many thanks for the opportunity to be here, to the faculty and the centre. It's great to be back. I've been back a few times since I've left, and sometimes it seems as if some things haven't changed, and some of the discussions we've had today have underlined that slightly pessimistic assessment, but I hope to be more optimistic. I suppose one of the most frequent psychological reactions of those who are actively engaged in the process of law reform, once one is getting close to achieving the goal, is sharp disappointment at the final product. Whether you're an activist or an academic, the evolution, and often in the advocate's mind, the degradation of initial drafts of a treaty or a legislative proposal that results from the compromises that happen in the political process lead to a tremendous feeling of letdown as you get to that final stage. And at times you feel tempted to abandon the effort with a sense of intellectual disgust at what has resulted, and the feeling that the whole effort has been undermined and rendered worthless by misguided, disingenuous or mean-spirited opponents. I say this as someone who's been involved in a minor way in a number of efforts of this sort. The Hong Kong Bill of Rights was one of them. The first round of anti-discrimination legislation in Hong Kong now a decade or so ago, a recent Human Rights Act in the Australian Capital Territory, and 2 international treaties, the optional protocol to CEDAW and the recently adopted UN Convention on the Rights of Persons with Disabilities, which I understand China signed yesterday in New York, are all examples of important initiatives that in that final stage aroused indignation and disappointment in the hearts and minds of those who had advocated them. But nevertheless, I think those cases illustrate the fact that once the initial disappointment has passed, the real significance of those achievements, whatever their limitations and problems, was realised, and the possibilities that they offered for advancing the real protection of human rights were able to be taken advantage of. I think from this morning's discussions, we face a somewhat similar situation in relation to the long-awaited race discrimination bill for Hong Kong. Whatever the drawbacks and limitations of the draft bill, and however long the wait has been, the introduction and eventual enactment of the legislation does represent a significant event in the history of human rights protection in Hong Kong, and it is important to recognise that achievement. At the same time, however, this is not to say that the bill itself is free from criticism on policy or technical grounds. There are many flaws, technical nature in the bill, and a number of the policy decisions embodied in it appear indefensible in the light of the international obligations applicable to Hong Kong and the government's stated commitment to pursuing racial equality and to living up to its obligations under the Racial Discrimination Convention. The other speakers today have engaged with these issues in detail, and they've provided incisive and constructive critiques of the bill and how it might be transformed from a flawed draft to a truly effective piece of human rights legislation. The upside is that there is still time to do this, and if the rhetoric of the government's professed commitment to ensuring the implementation of the Race Convention is sincere, then there should be no political impediment to significantly improving the legislation either. I don't propose to undertake a detailed critique of the bill, since that's been done so effectively already. I would instead like to reflect on a number of aspects of the history and of the process of the emergence of the legislation and its relationship to the international standards to which it is intended to give effect. The purpose of this is not just for the indulgence of historical review, but it may help to inform the strategic direction or strategic decisions and the tactics of a political struggle and a legal struggle which is reaching in many ways its critical stages. There are 4 issues which I would have liked to address, but I'm only going to have time to touch on 2 of them today. They are firstly the history efforts in relation to racial discrimination and the implementation of the Racial Convention in Hong Kong. Secondly, the discourse of policy making, the elaborate dance that Hong Kong government has engaged in over a period of 20 years in relation to this issue. Thirdly, and a very important one, I think, the role of international standards and external international bodies in helping to keep momentum going, and the important role of domestic advocacy, in fact, the critical role of domestic advocacy. And then fourthly, the spirit and letter of the convention and how it links up with the Race Discrimination Bill. But I'm going to limit myself to the history and the issue and the discourse of policy making, and even those will be fairly brief. First of all, I want to comment on the perspective that has been portrayed in recent government discussions of the bill and the international obligations which it is intended to implement. It's now over 40 years since the Race Discrimination Convention was adopted by the General Assembly of the United Nations, and only a couple of years short of that since the Convention was applied to Hong Kong by virtue of United Kingdom ratification in 1969. While it's true that the issue of the Convention and domestic legislation to implement it did not attract an enormous amount of attention in Hong Kong until the late 1980s or even the early 1990s, the obligation to enact racial discrimination legislation has existed for that period of nearly 40 years. And indeed, as we know, the UK has had racial discrimination legislation since that time as well. The UK appears to have provided very little information to the Committee on the Elimination of Racial Discrimination that P.Y. Lowe spoke about this morning, about most of its dependent territories during the first decade of the CERD Committee's work, in the 1970s basically. And it's only in the early 1980s that the committee began to request more information on the dependent territories. That picked up pace in the 1980s and in the 1990s. The approach of the handover in 1997, the suppression of the pro-democracy movement in June of 1989, and the increasing human rights literacy and activism of Hong Kong human rights advocates translated into calls for action based on international standards, and the concerted use during the 1990s of all the reporting procedures of all the available UN human rights treaty bodies. They were used very effectively to ventilate issues and to put pressure on the Hong Kong and United Kingdom governments. From the late 1980s and into the 1990s, the UN human rights treaty bodies again and again called on Hong Kong to give effect to its international obligations and to introduce anti-discrimination legislation, including race discrimination legislation. Part of the domestic efforts in that regard, of course, was the introduction of comprehensive Equal Opportunities Bill that was mentioned earlier, which Anna Wu, who of course is here today, implemented, and which helped spur the anti-discrimination legislation which we have today. It's interesting in the light of that history of nearly 30 years of engagement, how the government has talked about the racial discrimination legislation, and how, I think we heard this morning, it's called not to be too impatient to have it all now, because this is relatively new. In its consultation paper in 2004, one of the reasons given for the considering the passage of legislation, in addition to increasing local demands for such legislation, was the demand from international bodies. The paper refers to calls by various UN human rights bodies in 1999 and 2001, and a visit made by the High Commissioner for Human Rights in 2002. The report the consultation paper refers, interestingly, to the initial report under the ICSCR in 2000 or 1999 or 2000, and the initial report under the Race Discrimination Convention, although I think by that stage there had been something like 13 or 14 reports which should have reported on Hong Kong. And in the discussion of the legislative initiatives, once again, there's no reference to the 1994 initiative by Anna, and in fact, a number of the issues which were addressed by that independent effort, in which I was lucky enough to be involved, have come back to haunt us and in fact still haven't been addressed in the current bill, and I'll mention some of them perhaps when I get another bite at the cherry in the final panel. So it's important, I think, to recall when we look at it that concerns about racial discrimination legislation are not just confined to the last 10 years. It's important to recall this, I think, because not only because what we're talking about now is the realisation of an enormous amount of social capital and investment of time by people, but also because of the substantive knowledge developed during that period that appears to have been forgotten or to be ignored by the government. The introduction of racial discrimination legislation is, in effect, a debt owed by government to the Hong Kong community, the payment of which is long overdue. And that debt should be repaid with interest after 30 years. The state-of-the-art and generously conceived bill is what the community deserves, should not be repaid at a discount. It's fine to talk of partnership when you are the partner that has the power to decide what others might get. It's fine to talk of responsibility if you're the one who's in the position to limit that responsibility. How has that happened? Let me move on to the second topic, the discourse of policy making. I think it's important to reflect on the rather elaborate policy-making dance in which the Hong Kong government has engaged in this exercise. It's a pattern which has been seen regularly in relation to other human rights and anti-discrimination law issues, and probably more broadly in relation to progressive legal reform initiatives. Others have come up with similar analyses, and I claim no great originality for it, but I think by rehearsing it, it enables us to locate us at the stage at which we are in this process, and perhaps will help us to strategize for the remaining processes. The first stage, and I think there are about 5 I've got, is to deny that there's any issue at all. As late as 1989, the UK and Hong Kong governments were prepared to assert at the international level that there was no racial discrimination in Hong Kong. An extraordinary but also understandable assertion in the context of a still colonial society in which race, national origin and ethnicity were an important element still in the allocation of privilege. This also, however, had a legal logic behind it. It reflected the position, subsequently, or at the time even, discredited, which was asserted by the United Kingdom, that if there were no racial discrimination in a territory, then you didn't need any racial discrimination legislation. The Third Committee rejected this very early on, but the United Kingdom was prepared to propound this and to come up with rather unrealistic and empirically non-verifiable assertions about what was happening in some or all of its dependent territories. The second step of that of acceptance, or limited acceptance. The acceptance that there has been some racial discrimination within the overall context of a racially harmonious community. But the instances of discrimination are sporadic, relatively minor, they're certainly not systematic, widespread or structured, and don't really need any major systemic response. The third stage moves from an acceptance that perhaps there's an issue and one has to do something about it, but legislation is not the way to address a problem which may or may not be large scale. And we've seen that over the years, that legislation is not appropriate or desirable because laws alone do not change attitudes, although it's never been suggested that laws alone are what it's all about. Education is what is needed, that self-regulation by business will be effective, and that legislation will have an adverse effect on Hong Kong's economy and rigidify its labour market. All arguments that we heard 10 years ago in relation to other discrimination. Interestingly, the economic cost-benefit analysis has not been raised in the context of race discrimination legislation in quite the same way in which it was with the others. And interestingly, there's been a lot of work done on this by the Australian Productivity Commission, analysing the economic impact of this form of legislation. The fourth stage, of course, is delay. To maintain that if legislation is appropriate or it's required by these international obligations, it should only be enacted if there is majority community support. This approach has been much criticised due to its abdication of government responsibility to show leadership and in relation to the more disadvantaged members of the community, its perverse majoritarianism, and its use of methodologically suspect assessments of that public sentiment. It's also interesting that the different rules seem to apply when it comes to other forms of suggested reform, political reform being one, I suppose. But it was effective in delaying serious progress on legislation for almost a decade, from the mid-1990s, at least legislation on race discrimination legislation. Given the transition that Hong Kong was undergoing from British to Chinese sovereignty, and the concerns that enacting racial discrimination legislation at that stage might become a means of perpetuating colonial privilege in a post- or neo-colonial Hong Kong, perhaps that was not surprising. The final, or the fifth stage, and the one which we have reached, I have renamed after the discussions about the Christmas tree, the Scrooge stage. The case where we have a miserly and grudging acceptance that there must be legislation, and I think this is the penultimate stage. There must be legislation, and therefore something is produced. And there are a number of common features of how this has played out in the context of discrimination law and human rights law. The draft that we get appears to be inspired by the question, what is the absolute least which we can do to be able to claim that we have carried out our international obligations and political commitments? We heard this morning talk from Carrie Lam of thresholds, and it's a minimum threshold, which is all that they seem to aspire to. So it's a grudging rather than a generous approach. It lowers the political bar, and by staking out a very extreme position, by offering the absolute minimum, it means that the government, when it compromises towards, which it inevitably must, will still end up with a relatively unambitious and conservative bill rather than one that might be more generous and more consistent with the spirit of the convention which it is implementing. The second aspect of this sort of legislation, and it's true of the race bill, the models drawn on from overseas tend to be, first of all, older and in many cases outmoded legislative models, often ripped untidily from their broader original context and failing to reflect updates to those original models. A steadfast refusal in many cases to include the latest developments from overseas. And secondly, they use implementation or enforcement institutions that are generally among the least effective available to choose from. And we saw that with the SDO and the DDO, in which the British model was chosen. With all due respect to the EOC, it was not perhaps the strongest model available, although of course it has been used. And that of course has set a new low bar for implementation of the Race Convention. Thirdly, wide-ranging exclusions of areas of legislation and policy from scrutiny under the bill, in many cases areas which are clearly covered by relevant treaty obligations and are important to the realisation of its goals. We've heard about them. Finally, unwillingness to explicitly acknowledge in the legislation its international source and to ensure that its provisions and spirit, that is of the international treaty, are incorporated. I found it quite astounding that a bill which is touted as implementing the Racial Discrimination Convention obligations applicable to Hong Kong contains not a single explicit reference to that treaty, either in the long title or an annexed or whatever. We do have the definition picked up, but it is the definition only of race. It doesn't pick up the definition of discrimination. It does not pick up the scope of coverage required by the Race Discrimination Bill. The final stage, and that's where we are, and that's where I suppose the big political advocacy and in which we have to put our heads down for in that final stage. But coming after that, let's not forget the job is only then begins, because we enter the stage of post-enactment resistance. Just a few brief words on this. I expect we will see what we saw with the SDO, the DDO and the Bill of Rights, patterns of resistance from various areas of government if they end up being covered, and we know the ones which they will be. It'll be those which haven't been able to carve out explicit exclusions or exclusions which are sufficiently broad. We know that government is not monolithic and that there are varying levels of support for and opposition to the goals of this legislation. So I think it's quite important, to avoid the unedifying position of the Department of Justice being forced to argue positions in court which are inconsistent with Hong Kong's racial discrimination obligations and with the positions which have been stated to international bodies. And that has certainly happened in the past in Bill of Rights litigation. And secondly, can we avoid government departments wasting public money fighting unprincipled cases resisting the goals of human rights legislation? And we've seen a number of them in recent years under the discrimination legislation. There are many other things that one might say, but I won't say them now. So thank you very much.
Thank you very much, Andrew. We'll take questions at the end after all the speakers have finished their presentations. I'm pleased now to introduce our second speaker, Dr. De Verens. He is the former director of the Asia Pacific Center of Human Rights and the Prevention of Ethnic Conflict. He's the founding editor-in-chief of the Asia Pacific Journal on Human Rights and the Law. He's also recognized as one of the world's leading experts on language rights and has written two important works on this topic, Language, Minorities, and Human Rights, and also a guide to the rights of minorities and language, which was published in 2001. He is currently working on a new book on language rights and a 3-volume book series on ethnic and internal conflicts worldwide. I'm also pleased to note that he was the first to set up a regular law course on Asia-Pacific human rights in an Australian law school and established what was then the first LLM in human rights in Australia. Please warmly welcome.
Thank you, Carol. Distinguished colleagues and friends, mesdames et messieurs. Bonjour. Salam alaikum. Namaste. Ni hao. I'm sorry I cannot speak Cantonese. I only know a few words of Putonghua. And the reasons I know some Mandarin is because my ex-wife is from Jilin, from China. And that is my connection with China, which is also in the neighborhood, as we are part of that region also. It's a pleasure to be back at the University of Hong Kong, and especially it is an honor to be invited to address this conference, which deals with a very significant and in some ways a very worrying development in your law. Just to put my presentation in context, I am an immigrant in the country I live. All of my life I have been a member of a religious, linguistic, and cultural minority. And therefore I share some of the experiences of some of you have as a minority. And those experiences are experiences of disempowerment, of being somehow forgotten, ignored, or sometimes worse, by the majority. I also must say that, as was mentioned this morning, I think that French is also a wonderful language, because French is my first language, and so I feel very attached to it and very close to it. I only have 15 minutes to talk about language and discrimination, so let me very quickly and concisely address a number of specific points which you will see identified in a few moments on the overhead. But first, how is it possible to conclude that language preferences may constitute racial discrimination? Now, on the face of it, it may not seem so obvious that there is really a direct link. But very briefly, the answer is that when language can be linked to particular racial or ethnic groups, then it can be possibly racially discriminatory, as I'll attempt to show in a few minutes. If you look at the definition of what is discrimination, racial discrimination, under the International Convention on the Elimination of All Forms of Racial Discrimination, you can immediately see that the concept of discrimination in international law under that treaty is not limited to a narrow concept of race, but actually includes descent, ethnic, or national origins. That means that people of different ethnic backgrounds are certainly also protected against racial discrimination on the basis of this convention. This is also quite clearly the view of the members of the Committee on the Elimination of Racial Discrimination, which, in their various concluding observations on how governments comply with the rights guaranteed under the convention, often mention directly that individuals of different ethnic background and minorities are protected. And they've done so in cases such as Iceland, Sri Lanka, Moldova, Austria, and many others, some which Kelly has mentioned earlier today, so I will not talk about all of those. Just to make a few comments on Iceland, the Committee on the Elimination of Racial Discrimination pointed out that its compliance with the Convention Against Racial Discrimination, well, it actually referred to the need to assist immigrants and other foreigners in their study of their own language. On Sri Lanka, it talked about the introduction of Tamil as an official language, in addition to the Sinhalese language with English as the link language. For Moldova, the committee mentioned the development of languages of ethnic minorities, and with Austria, it mentioned assistance for new immigrants by providing free advice in their native language. I could give you many more examples, but notice that in some of these, you have indications from the committee that the prohibition of discrimination may require using other languages in addition even to the official language, including inappropriate circumstances, the use of the languages of some immigrant groups for educational purposes. The reason language is connected to race is because language can sometimes be a marker of ethnic or racial background. But you have here in Hong Kong, you have provisions in the proposed anti-discrimination legislation that I think is problematic in the sense that it may prevent claims of racial discrimination because of language preferences, or especially Clause 58, which we referred to earlier, but also Clause 3. Kelly has referred to these. Carol, quite a few people have mentioned these already. And I am not, of course, an expert on the administrative legal system here. However, if I can express an opinion from the outside looking in, from the point of view of international law, provisions like Clause 58 and Clause 3, I think, risk creating situations where racial discrimination may possibly be sanctioned in Hong Kong. They will be permitted to occur. I do not believe, I prefer not to believe, that we are saying that racial discrimination is permitted in this country. I truly believe that that is not what the Legislative Council wants to say, but the impact of what we're seeing with Article 58 and Article 3, I think, raises a problem, a serious difficulty. When you read Clause 58 in particular, it seems to be saying that Hong Kong's language policy, as expressed under the Official Languages Ordinance and other sections of the bill, excludes language issues or consideration from the prohibition of racial discrimination in a number of areas. That, ladies and gentlemen, I think is a wrong approach. It is an unnecessary approach, and it is a risky approach because it may create situations where Hong Kong could end up violating international law, could end up permitting situations of racial discrimination, and therefore going against, contradicting our obligations, your obligations, under the Convention Against All Forms of Racial Discrimination. And I think, as Andrew and others have mentioned earlier, it's ironic that legislation that is supposed to be adopted in order to implement your international legal obligations under treaty law should, in a sense, be suggesting that Hong Kong must be allowed to practice some form of racial discrimination in some areas. I think that's shameful if that is the case. So let me make this very clear. In international law, you must not try to hide behind, for example, a language exception in order to discriminate. That has now also become quite clear in a number of cases and communications where the UN Human Rights Committee, the European Court of Human Rights, and other international bodies have said no. They have rejected, they have waved aside that kind of argument. You cannot ignore non-discrimination. You cannot ignore international human rights law. You cannot violate a human right because of a language exception or some other type of clause. You have a series of basic human rights that include sometimes language. And some of the cases and communications I can mention, for example, not always well known or understood. Valentine versus Canada, 1993. The UN Human Rights Committee said that the right to use a language in private activities is guaranteed by freedom of expression. Diergaard versus Namibia, a more recent case, communication of the UN Human Rights Committee, said that a minority language had to be used to some degree by official authorities in addition to English, the official language, in order to be not discriminatory. More recently even, case of the European Court of Human Rights, Cyprus versus Turkey, changes our understanding, by the way, of the famous case of the Belgian linguistic case. And there the court said that the right to education could include the right to be instructed in a minority language in the public school, even if this is contrary to the official language legislation in place. One thing you should notice, these and there are other cases I could have mentioned, these are very recent. They're not old. And because they are so recent, many governments do not understand their legal obligations under various human rights treaties that impact on language policies. And I'm afraid that this is obviously unnecessarily and unfortunately probably what is happening here in Hong Kong. Finally, let me mention the practice in a few jurisdictions where they have had to reflect on the connection between language policies and preferences and racial discrimination. In places such as the United States, and we'll have other speakers mentioning it also, in Canada, just to give those two, there has often, not always, but often been the acknowledgement that some language requirements may constitute racial discrimination or national origin discrimination. That is the case under Title VII of the Federal Civil Rights Act of 1964 in the US, which, among other things, says that discrimination based on language is a form of national origin discrimination because primary language is closely related to the place a person comes from. In Ontario, to give one more example, the Ontario Human Rights Code essentially says that although language is not explicitly identified as a prohibited ground of discrimination, the Commission accepts complaints under a number of related grounds such as ancestry, ethnic origin, place of origin, and in some cases, race. Language and race are not identical, but sometimes there are situations where we can say they are linked to a particular race through national origin or ethnic background. That is the connection between language and race. That is the connection which can raise issues of racial discrimination. There are many more possible examples in countries from all over the world. But the message from these jurisdictions, I think, is fairly clear. As Kelly also mentioned this morning, unless it is reasonable and justified in the circumstances and in pursuit of a legitimate objective, a language preference can constitute racial discrimination, whether or not it involves an official language. Race being understood to include national origin or ethnic background, and therefore language can be included under one of these grounds under American federal, Canadian, and many other national laws. Now, I want to clarify one thing because I think it's been raised on a number of occasions this morning. Non-discrimination, even if we're talking about racial discrimination, it does not mean that all languages must be used all of the time by government departments or businesses everywhere at any place. It's a mistake. It's a misunderstanding as to the relationship between language and non-discrimination. What the UN Human Rights Committee and others have said, but especially the UN Human Rights Committee in the case of Diergaard, is that where you have a large number of individuals who use a language, or where there are extremely serious consequences in not reasonably accommodating a language need, then it can raise an issue of discrimination. Sometimes it may be an issue of critical mass, but also it may be an issue of where it is desperately needed, and it may be relatively simple or feasible to accommodate a language need. And I'm thinking of the situation of health, of medical care. There are different mechanisms used by different countries, using sometimes telephone interpreters in special cases, even new technology. There are all kinds of mechanisms responding when there is a concentration of individuals and so forth. To conclude, I still have a few minutes left. I'm doing very well.
Doing very well.
Thank you. To conclude, the provisions of the Race Discrimination Bill, such as Section 3 and Section 58, which seem to make exceptions that exclude government officials, employees, and makes exception in the case of language, are dangerous. They are dangerous because they appear to permit exceptions, including in the area of language, that would permit situations of racial discrimination in violation of international law and in violation of Hong Kong's obligations under treaties like the International Convention on the Elimination of All Forms of Racial Discrimination. There is, in my opinion, no valid reason that racial discrimination, which can manifest itself through language, should be allowed here in Hong Kong. You are not a racist society, or you should not be. Your government is not a racist government, and there should be no place for a law which in the end may condone some forms of racial discrimination, whether intentionally or not, because of the flaws in the Race Discrimination Bill when it comes to language, among others, but there are many others. Creating exceptions for language or anything else means not applying the prohibition of racial discrimination in specific areas. And that, mesdames et messieurs, is a violation of international law because such exceptions are simply not allowed, period. Racial discrimination is unacceptable and reprehensible. It is against international law, both under treaty and custom, and there should be no place for allowing it in legislation, either here in Hong Kong or anywhere else in the world. To improve the bill, you should probably, very probably, remove those provisions such as Section 58 and Section 3, which to my mind actually creates situations of inconsistencies with the legal obligations of Hong Kong under the Convention Against Racial Discrimination. The cases, well, really the cases that I've mentioned earlier today, and the anti-discrimination laws, which shows that such exceptions are not acceptable, not necessarily, and not appropriate. We were using the imagery of a tree, Christmas tree. I'm not sure really that was a good image to use, but we've been using that since this morning, so I think I'll continue also. I actually grew up in Canada. That's why my first language is French. And I come from a region where we actually grow Christmas trees, ironically enough. And the thing about a Christmas tree is that you just don't plant it there and then it happens. You actually have to prune it very carefully from the very beginning so that its shape, its leaves are actually appropriate for its role. We have here a bill where you have branches sticking out. You have gaps here and there with exclusion clauses. This, ladies and gentlemen, is not a Christmas tree. It is, in fact, a rather horrible-looking creature. It is ugly. It has exclusions. It has gaps. It has areas where, in fact, you risk creating a situation where you will permit racial discrimination because it's part of your law. That should not happen. I think that unless you prune the Christmas tree immediately to make sure that it can function properly, the role that it is supposed to fulfill, then you will have a serious problem in the future. Mesdames et messieurs, ladies and gentlemen, thank you, merci, 谢谢.
Thank you very much. We have now had two excellent presentations that try to put this bill in the context of international law and Hong Kong's obligations under international law. I'm delighted to welcome our next speaker, Professor Aileen McCulgan. She is going to help us compare the bill to recent developments in UK anti-discrimination law. And that's very important because Hong Kong often does look to the UK as a model. She is a professor of human rights law at King's College, London, and a barrister at Matrix Chambers. She specializes in human rights, labor, and discrimination law, and she's the author of a number of textbooks, including Discrimination, Text, Cases, and Materials, and Labor Law, Text, and Materials. And she's also authored a wide range of articles, in particular in the area of discrimination. And I'm particularly happy that she was able to come and travel quite a long way to help us with recent developments. Please welcome Aileen.
I'm just assuming this is my...
Yes.
This is what I use?
Eddie will help you. Eddie is the master.
Thank you. It's my pleasure to be here, and I will attempt to avoid justifying the cost of getting me here by running over 15 minutes. But as Carol said, I'm going to say a few words about the UK perspective, and in particular developments which have occurred in UK race law post the point at which it appears that the Hong Kong Legislative Council has snapshot the UK as a model, because quite a lot has changed in the UK, which puts the race discrimination bill here at odds, significantly at odds with the current Race Relations Act. Now, very briefly, the framework in the UK in which the Race Relations Act has to be understood is a framework which consists of that. There's lots and lots of anti-discrimination legislation. As of 2006, we've had legislation covering not only sex, race and disability, but also sexual orientation, religion or belief, and age. We've also had recent legislation which has pushed out discrimination legislation dealing with religion or belief and sexual orientation beyond employment, which is where it started off, into the area of goods and services, housing and so on. Age discrimination is regulated only in employment, but the Single Equality Act, question mark, which I assume we'll have within a few years, may or may not raise the bar for age discrimination legislation too. And this is not supposed to be a lecture on the UK's discrimination provisions, but the failure, for example, of the UK Race Relations Act to include religion as such has to be seen now in the context of a legislative package which does regulate discrimination on grounds of religion. Very briefly, these are the forms of discrimination that the Race Relations Act covers. I would make the point that direct discrimination is covered discrimination on racial grounds, and that can be where I'm discriminated against because of my own race, because of my husband's race, because of my friend's race, or because of the race of a customer who I'm instructed to discriminate against and refuse to discriminate against. That counts as race discrimination against me. So it's a very broad approach to race discrimination. In terms of the scope of the discrimination law, as with the Hong Kong bill, it covers employment, education, provision of goods and services, and housing. I note with interest that there are exceptions in relation to employment. There are small employer exceptions in the Hong Kong bill, and also exceptions in relation to death and retirement. There are no such exceptions in the British Act. More interesting, however, the British Act now covers discrimination in relation to public functions, and this stands in interesting contrast to Clause 3. Clause 3 appears to be modelled on the previous British position. the British legislation never explicitly excluded governmental functions, but in a very ungenerous decision of the House of Lords in an immigration case, it was a sex discrimination case, but it was applicable to the Race Relations Act. The House of Lords, in a case called Amin, decided that the goods and services provisions of the Race Relations Act only applied to the government when it was acting in a way that a private sector actor might act. And this caused great difficulties in the UK context. This is not a lesson that one would want to emulate, because there was complete confusion as to what were these functions that a government could perform which were similar to private sector functions. The big question mark arose in relation to the police, in relation to adoption type services, in relation to prison service. And if the prison service was acting as a provider of employment, as where a prisoner was applying for an in-prison job, then the Race Relations Act did apply, because employment is the kind of function that a private sector provider might provide. If the government was making immigration decisions, it didn't apply. If the police were providing, if the police were arresting you, it didn't apply. But query if the police were responding to your complaint about having been beaten up. In any event, there was a scandal in the UK after the death of Stephen Lawrence, who was a young black man who was subject to racial murder, and a totally ham-fisted investigation by the Metropolitan Police, which disclosed an absence of concern about the murder of a young black man. And in the wake of that, the Macpherson report concluded that the police were institutionally racist, and the Race Relations Act was amended in 2000, and the result of the amendment was the application of the prohibition on discrimination to public functions, most importantly the police. Not only the police, but perhaps most importantly the police. So to model the Hong Kong bill on a UK act which doesn't cover public functions, governmental functions, is flawed indeed. Particular issues of interest to Hong Kong. I've been asked to mention definitions of indirect discrimination, in particular justifications, the UK exceptions to the prohibition on race discrimination and immigration decisions. I would say the whole exclusion of language and nationality is extremely interesting from a UK perspective, because race under the Race Relations Act covers race, oddly. Race is race, national origins, ethnic origins, colour or nationality. So nationality is one of our protected grounds. It is subject to somewhat broader exceptions than the other grounds for obvious reasons. Well, they'll be obvious when I come to them, but it is nevertheless covered. And the exclusion of language is bizarre to an outsider, given that many instances of particularly indirect discrimination in the racial context will be language driven. But I think I don't need to say any more about that, except that actually the irony of the language issue struck me this morning, because in the UK at present we're in the middle of a debate about the perceived failure of multiculturalism and the need to integrate not only new arrivals but also second generations of immigrants, to integrate them into UK society in order to put an end to the disaffection which causes concerns about involvement in terrorism, for example. And to hear that non-Chinese speakers are having difficulty in being educated in Chinese and then not being eligible for jobs because of a lack of Chinese, and then being told that the Race Relations Bill won't cover that, is bizarre from an external perspective. But I'm going to press on and look at a few technical issues, which I'll start with the definition of indirect discrimination, because I understand that the Hong Kong legislative body has decided to adopt the old definition of indirect discrimination in the Race Relations Act on the basis that it's been tried and tested. It has been tried and tested, and it failed the test, which is why it's been replaced by a new definition of indirect discrimination. I mean, bizarrely, this definition does still apply to nationality and colour, but that's only because, to quote Andrew, our government has done what was the absolute minimum it could do in implementing European provisions. So it only implemented where it needed to, thus sticking with this rubbish old definition of indirect discrimination for nationality and colour, but for other grounds, race, national and ethnic origins, it has moved to a better definition of indirect discrimination, which I will come to. But this definition of indirect discrimination is, I think, consonant with the one which is in the sex discrimination ordinance. And what we have discovered has been problematic with this has been a number of issues. One is the requirement or condition. Requirement or condition has been interpreted by the domestic courts to require that an absolute bar applies. This was in a case, the Court of Appeal decided in a case called Pereira, and Mr. Pereira had been subject to a number, well, he wanted to get a job in the civil service, and he was told that there were a number of factors which counted against him. The fact that I think he hadn't been educated in the UK counted against him. The fact that he didn't have an English language GCSE counted against him. He said these things are indirectly discriminatory. Surely if I need to speak English, I need to speak English. But these particular factors that you're taking into account impact disparately on me as an immigrant. And the Court of Appeal said, oh, well, none of them are absolute bars, so these don't count. You can't claim indirect discrimination. On that analysis, an employer who says you can have this job if you've either played international rugby or you're 6'5" isn't discriminating indirectly on grounds of sex, because you don't have to fulfill either of those criteria. Neither one of those criteria is an absolute bar. So this is a nonsense. We've still got it in a little bit of the Race Relations Act, but it's bizarre to adopt this approach. The other difficulty, or one of the other difficulties with this, is it's in subsection 1, the proportion of persons of the same racial group. This emphasis on proportions in some cases requires elaborate statistics to be provided, and that is hugely difficult. It's particularly difficult. It's more difficult with race than it is with sex, but it's difficult enough with sex. And the new definition that we've adopted avoids this problem with statistics. The next problem with this approach to indirect discrimination is that it requires that the requirement or condition is to the detriment of the other because he cannot comply with it. I mean, the example that springs to mind is a sex example, actually. If I can't work full-time consistent with my childcare responsibilities and it's a well-paid job, a tribunal subject to this test might say, well, you can afford a nanny and then you can work full-time. But that's not an answer to a sort of an appropriate balance which someone might feel is required in their family life. Well, the new definition of indirect race discrimination, which we have, overcomes all of these problems. There it is. A person discriminates against another if he applies to that other a provision, criterion or practice. This is hugely wide and certainly doesn't require an absolute bar, which he applies or would apply equally to persons not of the same race or ethnic or national origins as that other, but which puts or would put persons of the same race or ethnic or national origins as that other at a particular disadvantage when compared with other persons. That doesn't require a statistical analysis. Which puts that other at that disadvantage. So you don't need to show it's impossible for you to comply, you just need to show it's disadvantageous, and which you cannot show to be a proportionate means of achieving a legitimate aim. Which brings me on to the next issue with the indirect discrimination definition in the Hong Kong Bill, which is the bizarrely multifaceted approach to justification. You can justify indirect discrimination if it's justified. You can also justify indirect discrimination on a number of other bases. And again, to an outsider, it's completely mystifying. It's either justifiable or it's not. It's not going to be justifiable if it's disproportionate or if it's not connected with a legitimate aim. And if it isn't connected with a legitimate aim and proportionate to that aim, why would you want to justify it? So it seems to be, it's more than a belt and braces. It's a kind of extraordinarily multi-layered, unnecessarily generous approach to the justification of indirect discrimination. I won't deal with most of the exceptions because they're not particularly interesting. But what I will say is, some of them just deal with if you're going to represent Britain at the Olympics, it's okay to require that you're British. I don't think many people would have a real difficulty with that. And that's the product of the Race Relations Act covering nationality discrimination. More interesting is Section 41. This is, in a sense, the response to Clause 3. If race relations legislation is going to cover governmental functions, there may be some occasions on which you need the government to be allowed to discriminate. Now, in the Race Relations Act, this only applies in a general way where the discrimination is on grounds of nationality. Basically, where a minister orders discrimination on grounds of nationality, then that is beyond, that can't be justified. Sorry, that can't be litigated under the Race Relations Act. It's horribly complicated, but that's the basic role of Section 41. Nationality discrimination can be made lawful by ministerial order. That's been interpreted narrowly. It will only be lawful where, or Section 41 will only apply where the discrimination is actually necessary to comply with the relevant ministerial order. And I've got a case in the Court of Appeal at the moment now, which is about how clearly does the ministerial order have to specify that it is wanting nationality discrimination. How clear does it have to be? Can government hide behind sort of unfocused orders? And I think the Court of Appeal is going to say it has to be very clear. So some nationality discrimination can be legitimated. This used to apply more broadly to other forms of discrimination, but it was narrowed to nationality discrimination because of European requirements, which are more rigorous. And we also have a national security exception. Nothing shall render unlawful an act done for the purpose of safeguarding national security if the doing of the act was justified by that purpose. So there are some exceptions in the domestic legislation in the UK, but those exceptions are quite narrow and are targeted particularly to discrimination on grounds of nationality, and certainly wouldn't justify the exclusion of nationality discrimination or the exclusion of language discrimination or the kind of very broad approach to justification which is to be found in the bill. Thank you.
Thank you very much. We're proceeding well on time. If our next two speakers can each take 15 minutes, we'll have 15 minutes left for questions, which would be wonderful. I'm delighted to welcome our next speaker, Malcolm Louie. Malcolm is a Soham visiting scholar at the University of Hong Kong Faculty of Law. He began his legal career by assisting in the first substantial litigation under the New Zealand Bill of Rights Act in 1990. Following his participation in the amendment of the New Zealand anti-discrimination legislation in 2002, Mr. Louie has been part of the government legal team responsible for responding to the new publicly funded complaints process for allegations of government discrimination. We're very pleased to have him here. We think he can offer the perspective of a government lawyer on what it takes and what can be done to comply with the government's obligations under domestic legislation and international law. Thank you so much. Please welcome him.
Thank you. Kia ora. G'day from New Zealand. Before I start, I'd like to thank the Soman family and HKU Law Faculty for their generosity in bringing me here for the past few months. And I'd like to thank and acknowledge the conference organisers although I'm a bit cautious about the extremely well-qualified panel that they seem to have put me in. I'd also like to point out to Kelly that I'm still working on my indirect discrimination claim on the basis of organising a conference at the same time as the Rugby Sevens, and I am a New Zealander. But I am talking to you today as a government lawyer, and I want to pull back a bit from the bill in the sense of there's been an enormous amount of comment by very well qualified people analysing the particular provisions of the bill, and I don't intend to enter that debate too much or repeat it. But what I want to say is that I do agree that the bill to me represents a need for more conceptual clarity about what you want anti-discrimination law to do with respect to the government as opposed to the private sector. And conceptual clarity is required in dealing with those two different types of activity, and the bill demonstrates to me a lack of clarity about those issues and therefore some real problems in its outcomes. Now, in dealing with that, what I'm going to try and do today is to talk about the idea of why should government, or try to convince government, that it's not such a bad thing to allow yourself to be open to these types of challenges, especially under a low-level resolution process like the EOC. So, just to start off, a few points for those who wish to challenge government about the way they do things and discrimination issues. And I fully endorse doing that. But a few things that, from my experience, I note, which is, although these debates, obviously because of the personal characteristics that are involved, get quite heated, I do believe that most civil servants want positive social outcomes within the limits of the resources that they have to operate under. I think few civil servants deliberately intend unjustifiably discriminatory policies when they're working on creating these policies. Policy processes themselves are complex beasts balancing a wide and diverse range of competing interests. In total, this really goes to the point of saying outcomes from policy processes are really perfect, and there is always going to be the chance that unintended outcomes result from those government policies, and that unintended outcomes may arise through simple progress of time and changing social context. The point is government should be able to deal with that, and that good governance processes should be in place to allow governments to try and accommodate that. For those members of government, I want to point out things like issues can be overlooked, as I've said. And because issues can be overlooked, population groups inadvertently disenfranchised. Now they've got to realise, government has to realise what that disenfranchisement means. It means low socio-economic status for a portion of your population. It means potential civil unrest. It means potential crime. It actually means, in many cases, harm to your economy. Migrant workers being a prime example. Lots of ethnicities might say, well, I'm not going to go to that country if I'm going to be subject to that sort of behaviour. Interests and values will change over time in society. Better methods for policy achievement may arise because simply better people come along who've done more research and can say to government, there's a better way of achieving what you're trying to achieve. Have you thought about doing it this way? I'd also like to point out to the government servants that as any civil society develops in a developing economy, so will civil rights litigation on human rights. We've heard a lot today about the limits of legal aid, and I'm a stranger to these shores and I don't know the system well enough to make comment about that. But as a general observation, I would say that no matter what the scenario, if you've got legislation that allows court challenges to government, someone out of the kindness of their heart will eventually say, I'm going to do that. And public interest litigation will grow. It will take time. Universities may get involved. Pro bono lawyers may start doing it, but eventually it will happen. As disenfranchised groups get organised, public interest litigation will happen. Governments need to be ready for that. They need to not view that as a threat, but view that as part of a process. It all comes down to what I like to call good governance. Good governance are systems that ensure legislation and policies that stand the test of time. I've borrowed from the Age Development Bank 4 markers of what they refer to as good governance. The first is accountability. Now, thinking about the low-level resolution of the EOC and the opportunity that provides a government in dealing with allegations of race discrimination, you do need to account for the fact that, as I said, discrimination-based litigation against the government is already possible. There's already the Basic Law, there's already the Bill of Rights Ordinance. There are already anti-discrimination standards that the government should be complying with and can be litigated. The EOC represents a less costly process for resolving and raising these issues prior to very expensive litigation, not just for the complainants, but for the Crown. The second good governance policy or principle is called participation. Now, we refer to this in New Zealand as participatory democracy. In other words, there is a value in low-risk methods for considering issues that, when your policy was created, you may not have thought about. And empowering portions of your population, often the disenfranchised groups, to engage in a process that enables them to feel like they've participated in policy development and review, that they've had the ability to raise their issues and contribute to the thinking about these challenges. There's an opportunity from the government to obtain buy-in on compromise solutions. Much of my work is about taking an issue that's been raised by a complainant, going to meetings, going to low-level resolution meetings, working with government departments to come up with a solution for that problem, and then saying to the complainant, what do you think about this? And many times you can work with complainant organisations to try and figure out how best to resolve it. Again, before a court finding that you've discriminated and before costly litigation. The third GGP, predictability. For civil servants, discrimination law and its complexities often just equals the fear of the unknown. They think they can't predict what courts might say, and they're afraid of what that might mean for government. But again, low-level resolution provides a non-threatening venue for consideration and testing of expert advice and new information regarding these issues. You can review and formulate government responses prior to the court process, even if it's an issue that I know is going to go to court and that I know the government is not going to see eye to eye on with the complainant group. There's actually, many people will say this is cynical, but from a government lawyer perspective, it's a great opportunity for me to gauge the strength of the opposition's case, to think about the information that they're raising, to think about my own information, and and give some thought to that. Finally, that predictability issue, or that work, allows the remaining issues that go to litigation to be much more focused. That means that when the issues that actually go to court often have cleared away the dross. All the side issues, all the related issues to the core discrimination claim have been dealt with at that low level. So that both sides know what the issue is, both sides know where the points of difference are, and the court is presented with a much better case to decide. Transparency. Government lawyers tend to really cringe about this. But once again, there are long-term benefits for government in doing this. A low-level resolution process like the EOC enables the government to present information and justification material at an early stage of the process. It lifts the veil of secrecy that many people think revolve around government and demonstrates an absence of malice or conspiracy against a population group. Courts often consider the openness of government in dealing with complaints and determining what remedy they will be imposing on government if they find discrimination has occurred. The way you behave at these early stages can have flow-on effects for the way the case is decided against you or for you, and government lawyers need to think about that. Overall, there's a few key lessons that I've learned in doing this litigation. Opening the government up to low-level resolution or low-level dispute resolution and allegations of discrimination does not mean the sky falls on the head of government. There has not been a floodgate of complaints and litigation. New unforeseen issues are raised and considered in a low-cost way. Government can review, update justifications or amend without the expense or intervention of courts. You can go to a court and say, we've been working on this because we've known about this complaint for months, and if you are going to find against us, we'd like you to think about making these orders or these findings, because if you go the other way and you allow a court to just come up with a remedy it wants to on the day, you could create even more problems for government. This process provides government an opportunity to prepare for litigation and gauge the strength of the opposition case in a way that also plays benefits for the complainant. The complainant can actually decide whether they want to continue. Lobbying may achieve everything they wanted anyway. In summary, the EOC's mechanisms represent a valuable opportunity for government to achieve good governance outcomes and enhance the quality of its policies and legislation. This opportunity should be embraced rather than avoided or restrained to the point of indifference. The drafters of this bill need to think very carefully about distinguishing between concepts of allowing themselves to be exposed to complaints about discrimination and the remedies that may be imposed or the consequences of a finding of discrimination. Invalidity of your act or policy is not always going to be the consequence, and you may be able to avoid that through these processes. Just because you're afraid of the consequences does not mean you should draft a piece of legislation that prevents these challenges and these discussions happening in the first place. And there is real benefits for government to enter that dialogue. Thank you.
Thank you very much, Malcolm. I hope your comments are heard by our government representatives, even if they aren't here any longer. But hopefully they'll be passed on. Last but not least, our speaker on American developments in American discrimination law is Ho-Ning Lau. Professor Lau is currently the Harvey S. Shipley Miller Teaching Fellow at UCLA School of Law, and he is about to take up a post as Associate Professor at Hofstra University School of Law in New York. He is a graduate of the University of Pennsylvania, where he studied international relations, and a graduate of the University of Chicago Law School, where he served as the executive editor of the University of Chicago Law Review. Prior to joining UCLA, Professor Lau worked for the law firm of Debevoise Plimpton in New York. He served as a consultant to the Hong Kong Human Rights Monitor, and his research covers a broad range of issues concerning equality theory and anti-discrimination law.
Thank you. Good afternoon. So I'd like to start by thanking CCPL and especially Kelly for having me here today at this wonderful conference. So Kelly asked me to talk about the American experience with race discrimination. And when she told me that, I thought, I'm very cognizant of the fact that many people around the world find Americans, especially the Bush administration, to preach the American way of doing things in a sort of unidirectional sort of way, and I thought, I don't want to do that today. I want my participation on this panel to be more dialogical, and to facilitate that, I thought instead of singing the praises of American law, what I'm going to do is highlight the flaws with American law, because I think it's important for Hong Kong not only to learn from progress abroad, but also the stumbling blocks and the mistakes that other jurisdictions have made. And, you know, I was very troubled by the fact that, oh dear, I forgot her name, but the First Lady who spoke today, you know, justified the Hong Kong proposed bill's definition of discrimination by saying, well, it already satisfies CERD's definition and also surpasses the definition of the EU. And I think that sort of logic is problematic, because Hong Kong should look at developments abroad as a baseline and think more critically about whether or not Hong Kong can improve on what has already been established abroad. Hong Kong is at a critical juncture right now where it has a chance not to just be a follower, but also to be a leader in terms of social justice and equality. So the flaw that I'm going to talk about is one that has been pointed out overwhelmingly, I think, by legal scholars of race in the United States, and that's the problem that American law does not protect against discrimination based on mutable racial traits. And so what do I mean by mutable racial traits, which I will also refer to as performative racial traits? So there are two types of racial traits. One is phenotypic. That means it's your biological component. It's the color of your skin that you were born with. But then there are also performative traits. Our sense of identity is not only the color of the skin that we're born with, but the way that we perform our identity in our everyday lives. And these performative traits are socially constructed traits that are associated with particular racial groups that we adopt because of the association with that particular racial group. So what are some examples? Examples can be particular hairstyles or a way of dress that's associated with a particular racial group. It could be someone who happens to be bilingual but chooses to speak a foreign language. You know, there's an aspect of choice there. It could be, insofar as religion and race overlap, it is the one's choice to adopt, for instance, headscarves or wearing a yarmulke. It could be the decision to wear facial hair because it is associated with a particular ethnicity. All right. And so the problem is the United States does not protect against discrimination based on these traits. So the first step in making out a disparate impact claim under Title VII of American law, disparate impact being the equivalent to a disproportionate impact claim, is that you have to show that an employment requirement in the employment context is based on a mutable trait that disproportionately excludes a certain racial group. All right? And so to clarify what this means, I'm going to give you three cases. The first one is the famous case of Renee Rogers versus American Airlines. Renee Rogers is an African-American woman who wore an all-braided hairstyle, and she thought that her all-braided hairstyle meant a lot to her sense of racial identity. She said that during the Black Pride movement of the 1960s, a lot of African-Americans wore this sort of hairstyle because it was an expression of Black pride. However, and she was told that this hairstyle violated American Airlines grooming code. American Airlines wanted their stewardesses to have straightened hair. And the argument was that this is neutral on its face, so there's no direct discrimination, and there's also no cognizable disparate impact claim because the trait is mutable. So the plaintiff, Renee Rogers, can easily change her hair, they said. This isn't a huge burden on her. And they said that, in fact, Bo Derek, in one of her movies, wore an all-braided hairstyle. And so why should we believe that this is correlated with African American identity? So this is one famous case in which the mutable trait of hairstyle was not protected. A second case is a language discrimination case, Garcia versus Glore, which is also a very famous case. And it's true that the Equal Opportunities Commission of the United States has spoken in favor of language rights. However, the EOC's guidelines are not binding on the courts, and overwhelmingly courts have chosen not to adopt the EOC's guidelines. So in Garcia versus Glore, an employer had a English-only office rule or employment place rule, that even during your break you couldn't speak a foreign language because the employer stated that it was necessary to foster cohesion at the workplace, and also it was a way to help non-native English speakers improve their English. And the court similarly said there that Mr. Garcia was bilingual, so he had a choice to whether or not to speak Spanish. And so easily he could speak English instead of Spanish, and so it wasn't a huge burden on him, and he couldn't make out a Title VII claim because him suppressing his second language didn't constitute a mutable trait, it was a preference. All right, and the third example that I'll give you isn't one that has been litigated, but one that has been written about by my colleague at UCLA, Devin Carbado, involving the fifth black woman. He calls this hypothetical the case of the fifth black woman. So this fifth black woman goes by the name of Lakeisha, an ethnic name. She wears her hair in an all braided hairstyle. She wears kente scarves, which are inspired by African culture. And she's denied a promotion, okay? Or she may be even be denied getting hired if she was on the job market. And she strongly believes that if you put all these factors together, she's being discriminated against because of her race. However, because disparate impact claims in the United States are so closely connected to statistics to show that a group has been disproportionately excluded, she might lose her claim. Because what does this law firm say? This law firm says, no, in fact, we've been very, very supportive of African American women. In fact, this past year, we gave promotions to 4 African American women to partnership. And this is breaking history in terms of all the law firms in this city. But what the problem is that if you look at these 4 black women, they don't have the name Lakeisha. They go by names like Mary and Joan, anglicized names. They straighten their hair with synthetic chemicals, and instead of wearing kente scarves, they assimilate by putting on their jewelry, wearing lipstick, wearing nice suits that conform to a anglicized white notion of beauty. And so there is no statistical evidence of discrimination here, and so Lakeisha doesn't have a claim. And Devin Carbado goes on to argue that these cases of mutable traits, even the one of Lakeisha, is problematic on 2 levels. On one level, these sort of requirements still burden the candidate with psychic harms. There's dignitary harms here because it compromises the individual's sense of race and sense of dignity. And there are also real economic costs. For Lakeisha to go to the salon and straighten her hair and buy the jewelry and put on her suit can cost a lot of money. So that is the problem that many legal scholars have pointed out in the United States with the current state of American law. I should point out, to be fair to the United States, that as Kelly pointed out earlier, there has been some protection of legal precedent with regard to language rights in the United States, with the case of Lau v. Nichols. Some question the precedential value of that case, though, because of some developments in administrative law. But what's great is that Congress actually enacted law to make the precedential value through statutes. So they passed the Equal Education Opportunities Act, which I think is a great thing. But why do I bring this up? I bring this up, and I think Eileen highlighted, hinted at this fact that this may also, if not today, one day be a problem in Hong Kong because of the way that it has framed its test for indirect discrimination. must confess that I don't know enough about statutory interpretation in Hong Kong or enough about the RRA. But I'm troubled by the fact that the test for indirect discrimination, two things about it. One is that it involves that statistical analysis, which means Lakeisha loses her case, and also because of the language "can comply," which is this absolute bar, which I think mirrors the language of mutability in American Title VII law. And so I hope that Hong Kong can learn from the criticism that American law has elicited from commentators in the United States, and think twice about the indirect discrimination test that it is about to or considering adopting.
Thank you very much. I'd like to thank all of our speakers for giving excellent presentations and also really making an effort to keep to time. I know you all had more to say and you really disciplined yourselves wonderfully. So we have some time for questions. We don't need to break for tea until 4. I think what Albert did was sort of a good approach. He took 3 questions and then we'll have some time for discussion of those 3 questions and see if we have some more time after that for additional questions. I'd like to ask you to try to make your questions as concise as possible so that we can allow for as much discussion as possible. Yes?
No. All right. Thank you very much. My name is Freo. I'm a student at the Faculty of Law. My first question is addressed to Professor Barnes.
Could you speak just a little louder? I know the acoustics in this room are not great, and the people in the back might not be able to hear you.
Okay, can you hear me now?
Yes.
Yeah. My question is addressed to Professor Barnes regarding history, the history of this bill as well as all the other ordinances having an impact on human rights here. In my understanding, the legal system, or the order established after the handover of Hong Kong to China was established by the Joint Declaration and then later the Basic Law. My question is, how much of an impact has the Joint Declaration have on such bills like race discrimination? Because in my opinion, it determines the policies which the Hong Kong government is going to come up with and implement during this period. And I also believe that that joint declaration and everything that comes after is based on some kind of contradictory premises. One is trying to maintain the status quo, which also includes the colonial, the previous system, plus trying to introduce some changes. So my question is, how do you look at the impact of the declaration on the system that came after? My second question is addressed...
Can I ask you to ask just one question maybe so we can get 3 questions from, and then if we have time we'll come back? Thank you. All right, so Andrew will prepare his answer to that question. We have a second person who'd like to ask a question? Yes?
Right, my question is to Professor Barnes. In Hong Kong, the administration often quotes the Belgian language case as an example. Can you give us a little comment on that? Because I think they also prepared a position paper to the Bills Committee explaining the Belgian language case. So I think if you can tell us more about it and how useful that case is to understand the Hong Kong situation, that would be useful.
Okay, and a third question. Flora, right behind you, Flora. Right, thank you.
One question for Andrew as well. I was wondering if a simple removal of clause 58 will imply that for schools they would simply switch all languages to English as a medium of teaching, because when I look at the tertiary education in Hong Kong, almost 8 universities are adopting or have already adopted English as the medium of teaching. So Cantonese are somehow, you can say, marginalized in this sense. So I was wondering if if there is no other laws or other recognition from the government of the local language that most people speak in Hong Kong to be recognized as a teaching language, will the simple removal of 58, Clause 58, imply that all courses will be switched to English as a medium of teaching? Yeah.
Okay, thank you. I think that's a very good question. Why don't we start with Andrew on the joint declaration, and then we'll move to the language questions.
Okay. It's a big question, and I'm not sure I'm the best person in the room to answer it. And perhaps some of the others here, like Margaret and Anna, might want to offer us their views on that. I mean, let me just give you the technical answer in terms of what you probably already know. In terms of the guarantees of equality in the form of the ICCPR and the Economic, Social, Cultural Rights Covenant have been constitutionalised and continue as a result of provisions in the Joint Declaration as well as international labour conventions. I suppose the oddity really is that although both China and Britain were parties to the Racial Discrimination Convention at the time of the handover, that hasn't been constitutionalised either. So it's a little odd in that we are trying to implement treaty obligations under one treaty and they're hanging sort of off provisions in the basic law which go back to the Joint Declaration on other treaties. I'm not sure that really answers what you want, but perhaps we can discuss it at the coffee break if it doesn't.
The Belgian linguistic case, that's a wonderful, wonderful case of the European Court of Human Rights. It is one of the great misunderstood, I think, of European law also. A lot of governments, a number of governments look at the Belgian linguistic case and believe it says that you have no right to education in your language under that case. That case used two provisions of the European Convention, the right to education and whether or not the law in Belgium discriminated on the ground of language. What the court actually said was that when you look at the law in Belgium, which permitted education, by the way, in 3 languages, and we tend to forget that. There are French schools in Belgium, there are Dutch or Flemish language schools in the country, and there are German language schools because there's a small German-speaking minority in Belgium. The European Court of Human Rights said 2 things. First, the right of education does not guarantee the right to choose the medium of instruction, the language used for education in a government school, in a state school. So the right to education is language neutral. But then it looked at the issue, is limiting the right to education in French, it was limited in some parts of the country, is that discrimination on the ground of language? Now I think that authorities here, the government in Hong Kong, has looked at that and they interpret it to mean that, in a way that there can never be any discrimination on the ground of language if the government designates an official language for education, for example. That's not what it said. The court said, when we look at the whole legislation in Belgium, Belgium is divided into language regions, that when you consider all of the circumstances in Belgium, is a reasonable language policy. Most French-speaking people in Belgium have education in their language. Most Dutch-speaking people have education in their language. Most German-speaking people have education in their language. Some don't, because they're in little isolated areas. The court said, well, when we look at all of this, we conclude there is no discrimination on the ground of language, even if you don't use one of these languages in some parts of the country. Now, a number of governments stop there. And they say, you cannot argue discrimination in relation to language because of the Belgian linguistic case. In reality, the other side of what the court said was that unless your language policy is justified, unless it's really reasonable in the circumstances, it will be discrimination. This is what I think is ignored in the approach the government has chosen. There are situations which can be discrimination on the ground of language, even in relation to education. And I'll say something else for the last question. If I am the president of the Republic of Hong Kong, And one of the first actions I do is say, all those people here who speak French receive $1 million. Or 10 million today, $10 million. That could be discrimination, couldn't it? Why? Because it's not reasonable, it's not justified. There's no legitimate objective to only give to those of you who speak French $10 million. So it is possible to have some language policy that are unreasonable, unjustified, and therefore discrimination. It is possible. It's just that in the Belgian linguistic case, the situation that existed there, the court said, oh no, in general this is reasonable, so there's no discrimination. That's the mistake made, I think, by the Hong Kong authorities. If they believe that the Belgian linguistic case closes the door completely to any argument of language discrimination, that's completely false. That's a misunderstanding about that. Now,
I think, does
sorry.
Aileen want to
Can I add one word?
Just she wanted to add one thing.
That the Belgian linguistics case was the first Article 14 case, and the European Court of Human Rights started off with a very low threshold in the approach to justification, and in the 30 or so years that have passed since that, the threshold has got higher, particularly in cases which impact on race. So it's just to agree that the idea that this gives carte blanche for language discrimination is simply wrong.
and one last comment very quickly to answer the third question. Oddly, it's a bit strange, but on the overhead on my presentation, I mentioned the case of Cyprus versus Turkey of 2001, only a few years ago. And in that case, the European Court of Human Rights did something very odd. It actually said in Cyprus, even without looking at discrimination, it actually recognized a right to education in a minority's language, almost automatically for a Greek-speaking population. The logic is difficult to fathom, to really understand completely. But really what that decision does, I think, is point out that the Belgian linguistic case is not the final word, and that in reality the European Court has actually changed its approach, and it said that government, even against its own official language policy, must accommodate the language of others in some circumstances. And here, in the case of Cyprus versus Turkey, it actually forced or indicated that high schools, secondary schools, must use a non-official language, even if it goes against the language policies of the government, because it's too inconvenient for parents. I'm exaggerating, but it is a very strange decision. But it opens the door, and yes, there is possibility of arguing that some kind of education must be provided in a minority language, but not for everyone all the time, everywhere. There still has to be some criteria of what is possible, what is reasonable, and what is justified in the circumstances. Thank you.
All right, Andrew has a question he'd like to ask Malcolm.
Yes, Mark, you launched into a discussion of the merits of this low-level dispute resolution in government, and I think you may have assumed that even those of us who live quite close across the Tasman may have known the details of it. So I'd be interested in if you could give us a quick description of how that works and how it relates to the complaints functions of the New Zealand equivalents of the EAC and the role of the Ombudsman and so on.
Sure. Sorry. If I look at the bill with regard to the powers of the EAC to conduct investigations and
Want the
to...
mic? Back. I used to teach in this room, so I know the acoustics are very bad in the back.
If I look at the bill and the EAC's powers to conduct investigations, and you see there's even a power to hold conciliation meetings, things like that. What we did in New Zealand was to broaden that a bit more in terms of terminology, and I would point out that many of the issues here in discrimination legislation is about terminology and different people having different understandings about what words, or they have different assumptions about what words mean. For example, when we talk about discrimination, many people think that discrimination is just the different treatment leading to disadvantage, whereas much of the case law recognises that to actually find discrimination, you're looking for that without a justified
objective that's proportionate, or a justified limitation, as I would call it. So, on the other hand, myself, I would say, well, I like to think that I have a discriminatory wine taste, and that's a positive, I hope, although my wife doesn't seem to think so. And what we're talking about here, what we're looking for, is unjustified discrimination. So once again, the government needs to think about, well, these exemptions that you have in your Act, what are they, other than sort of saying we want to protect actions that are not justified? Because within your definition, you may already have a discussion about whether it's justified in the context. Now, to get back to Andrew's point, the point is that the Human Rights Commission in New Zealand is able to take all complaints, or most complaints, about allegations of discrimination in government legislation and policies and actions. We have that sort of investigation, or more a mediation process, where the parties sit down and put their case to each other and try and figure out whether they can resolve things before you get to litigation. And it means an airing of the issues. It means that I drag my client departments along to this meeting, and they get to hear from the people who are actually being affected by their policy. They get to hear how people's experiences and the discrimination they might be experiencing because of those policies. I find in a lot of these meetings where it is, you encourage your clients on both sides to be open about their dialogue, sometimes you find that officials who are at the senior level in government will say to the complainant, what happened to you is actually the misapplication of the policy. That actually someone in the front line has made a mistake, or that the policy isn't supposed to be interpreted that way, or we hadn't thought about that, or there's actually a legislative amendment in the line to deal with that. Now, I've also been involved in litigation that avoided all of that process, and it was appalling because many of those issues came up in the litigation. And we wasted, both the complainant and the government wasted thousands of dollars because we never had that process. And my point is that what we've seen so far is that we opened it up, and there were all the same types of concerns that I see, or I sort of assume are happening here in the Hong Kong environment, which is various government departments sort of saying, oh no, that's really going to detrimentally affect the way we operate. We've got some really core concerns, and we don't want to open those up because people will take extreme views about what is racial discrimination. But actually, when you do the low-level resolution and you don't have to go to a judge, you can actually resolve many of these issues. And departments themselves can often figure out ways to avoid the consequences of unintended racial discrimination or any discrimination. So that process is actually a broadening and moving away from the classic ombudsman style of investigation and determination in reports, and actually having a much more open dialogue. I would also point out, though, that when I made the point about dividing your concepts about what you want to expose yourself to in terms of allegations under this legislation and remedies is also important. PY in his earlier paper talked about their provision regarding statutory enactments and excluding actions taken under statutory enactments. My view is that there's still benefit to be gained by allowing an organisation like the EOC to take complaints, to do a report advising whether something's inconsistent with racial discrimination concepts, even though they may not be able to strike down the legislation, or even though it may not make that legislation invalid. Because when you're talking about invalidating legislation, you are getting into constitutional issues that have already been discussed in other spheres. But the value of taking that complaint and writing that report and doing that work for the government cannot be underestimated. And I think many government officials just miss it.
Right. I think it really does point to the conclusion that Clause 3 has to be amended. And the government may think that it's protecting itself by not letting the EOC take complaints about things like racial discrimination in the police, but actually it would be better if the EOC could offer its services to people. Now, I think we realized we didn't quite answer the question on the use of Cantonese, so we're going to finish with that question and then we'll perhaps take a tea break.
In relation to that, there's a bit of a problem. Is Cantonese, or is there one Chinese language, or are there more than one Chinese languages? I'm not an expert, I can't answer that. But it is a difficult question in a way to address, because the laws, international law dealing with discrimination, refer to language, for example. So that will have to be answered. Are we really talking about different dialects? And I notice that the Chinese government refers to dialects, doesn't refer to different languages, of course. This is an area, if I talk about point of view of international law, which is still evolving. It's quite new. Remember those cases I had on my presentation, 1993, 2000, 2001. So it is a bit of a challenge, or it is an area which is still developing very much. My opinion is that, yes, we are talking about different languages. And it may eventually be possible to make that kind of argument. But the difficulty is, it is an area which is, because it's still changing, especially at the level of international law in relation to non-discrimination, it will take time to clarify. And I think it would be difficult to make that kind of argument currently, the current development of international law. Removing Clause 58, would that permit a larger number of Cantonese programs, language, universities that teach in Cantonese? No, I don't think it would, because Clause 58 and the Race Discrimination Bill is quite limited in the areas of jurisdiction, of competence, of what can be done. EOC would have a number of powers, but EOC would not have the power to open up Cantonese language universities. You need actually to look at the constitutional order system here to determine how could you change directly certain laws in Hong Kong, because that's what you would have to do. Plus, it would have to be accepted or understood that Cantonese is a language. Putonghua, Mandarin, is a language. They're all written basically the same way, but there are differences which mean that Cantonese can be treated as a language, and maybe there are some aspects of the higher level education, university level education, that's not reasonable, given the number of Cantonese speaking people in Hong Kong. So all that matter is it reasonable and justified in Hong Kong to have the universities, I think, almost completely teach in Mandarin? Is it? That's the kind of reasoning that would have to be done. So very, very difficult, but, there are possibilities, yes. Thank you.
All right. I know there are more questions, and I would love to continue the discussion. However, in fairness to my colleague, Richard, who is the next chair, I'm going to call an end to the session now so that you can all have a tea break and we can come back and start on time at 4:15, please. Thank you. Actually,